We will begin the plenary session under the theme 20 Years of IP Administration. We will start with a keynote speech by Mr. Tomonori Honda, President of the Intellectual Property High Court. Mr. Honda, the floor is yours. My name is Tomonari Honda, President of the IP High Court. Thank you very much for joining the plenary session of JSIP 2025 today. The IP High Court was established on April 1st, 2005 under the Act for the Establishment of the IP High Court. This April marks the 20th anniversary of its establishment. This plenary session was organized to commemorate this milestone and to look back on the 20 years history of the IP administration and the judiciary. I'd like to begin by briefly introducing the path that the IP High Court has taken during these 20 years. As stipulated in Article 1 of the Establishment Act, the IP High Court was founded to enhance and expedite judicial proceedings concerning IP in view of the growing importance of IP protection and the expanding use of IP in Japan's economy and society. The court was established as a specialized judiciary for IP-related cases. Having said that, the history of Japan's judiciary handling intellectual property cases is long, as a dedicated division for IP cases was first established in November 1950 at the Tokyo High Court. In March 1958, another specialized IP division was created within the regular departments of the Tokyo High Court, and later the number of divisions increased to 4, allowing the court to handle IP cases more efficiently. Then, in October 2022, the IP High Court relocated from the Kasumiga City Joint Government Building, which it had shared with the Tokyo High Court and District Courts, to its current building in Nakameguro, Tokyo. Today, it serves as a special branch of the Tokyo High Court, exclusively handling IP-related cases. Specifically, the IP High Court has exclusive jurisdiction over appeals in patent infringement cases and over actions seeking revocation of JPO trial decisions. In particular, for technical cases such as patent and utility models, the Tokyo District Court and Osaka District Court have exclusive jurisdiction at first instance, and appeals from these courts come to the IP High Court. This means the IP High Court handles IP appeals from all over Japan, bearing a significant responsibility as the nation's only specialized appellate court for IP cases. Next, I will discuss the case handling statistics. The slide shows the number of infringement cases handled by the IP High Court and the average duration of proceedings over the past 20 years since its establishment. Although the number of infringement cases varies from year to year, since 2005, it has generally remained around 100 cases annually. The average duration of these infringement cases also fluctuates annually, but I would say it generally ranges from 7 to 10 months. Next are the revocation actions against JPU decisions, in which the IP High Court reviews appeals filed against the JPU's trial decisions. Although not shown on the slide, the number of such cases was nearly 600 around 2005, but it has steadily decreased over the years, reaching 116 cases only last year. The average duration of these revocation cases also varies annually, but remains roughly between 7 and just under 10 months. To summarize, Before the establishment of the IP High Court, for example, around 1999, the average duration for infringement trials was about 13 months, and for revocation trials, about 14 months. Therefore, it can be said that significant progress in expediting proceedings has been achieved. Next, I will introduce the systems adopted by the IP High Court to handle highly specialized IP cases. The IP High Court strengthens its expertise through two systems, the judicial research officials and the technical advisors. Judicial research officials analyze each case carefully from a technical standpoint and report their findings to the judges. Technical advisors, meanwhile, provide expert explanations during technical hearings, which helps deepen the judge's understanding of the cases. There are currently 11 judicial research officials at the IP High Court. Most of them are experienced former JPO examiners or trial examiners, while some are also skilled patent attorneys. The technical advisors consist of about 200 leading experts from across Japan, including university professors, researchers, and patent attorneys, and specialists from both public and private research institutions as well. To date, more than 2,400 technical advisors have participated in intellectual property litigation proceedings. As you see at the bottom of this slide, so they are picturized. This one. Again, during technical hearings, judicial research officials and technical advisors take the bench alongside judges, listening directly to the parties' technical explanations. The systems of judicial research officials and technical advisors, characterized by their high level of expertise and practical usability, are world-class frameworks that enable the IP High Court to render fair and accurate judgments even in the most complex technical cases. One distinctive feature of the IP High Court's proceedings is the grand panel system, in which 5 judges deliberate together. This system allows the court to establish uniform principles on major legal issues in IP litigation, contributing greatly to consistent dispute resolution. Since its establishment, the IP High Court has issued 16 grand panel judgments, among them in the rail era. Notable ones included the CO2-containing viscous plastic case 2019, the beauty device case 2020, the massage chair case 2021, the comment distribution system case 2023, and most recently the plastic memorial offering case 2024, delivered this year. To enhance the effectiveness of the grand panel system, the third-party opinion solicitation system has been introduced. Under this system, when deemed necessary upon a party's request, the court may invite the public to submit written opinions on matters such as application of the Patent Act and relevant issues.
And the necessary matter related to the case when it deems necessary. This system was introduced in 2021 at the revision of the Patent Act, and it is a Japanese version amicus curiae. Since the law was revised, this has been used to grant panel cases to date. So in this way, IP High Court is conscious of its law as a standard setup for intellectual property cases at the High Court level. And issuing grand panel decision, it strives to provide practical guidelines at the early stage. Furthermore, the IP High Court has been mindful of the trend toward digitization and actively utilized digital technology to enhance convenience for the parties involved and strive to conduct through hearings. First, the civil procedure. document electronic filing system, commonly known as MINTS, is a system that allows briefs and other documents to be submitted electronically. Since its introduction in 2022, it has been used nationwide. It boasts a particularly high usage rate in IP High Court proceedings among all courts nationwide. Furthermore, from March 2023, the pre-trial proceedings will be conducted via web conference, and from March 2024, proceedings will be conducted via web conferencing. And at IP High Court, especially technology-related cases, by using the web cases, so utilizing web conferences, parties and their attorneys can participate in hearing without any burden. Furthermore, revised law regarding the e-filing of the complaints and electronics storage of litigation records will come into effect by May 2026. IP High Court hopes to further utilize digital technology to conduct thorough hearings. The IP High Court has recognized from an early stage the importance of disseminating information from the court and has been working hard to do so for the past 20 years. We have primarily focused on providing the information through brochures and our website, introducing the court activities and case laws to the public. The general explanation of the IP High Court's website have been translated into Japanese, English, French, German, Chinese, and Korean, making it possible to provide information about the Japan's Intellectual Property High Court in a variety of languages. One notable feature of the IP High Court's information dissemination is the prompt and comprehensive disclosure of court precedents related to IP High Court. The IP High Court, the website, publishes case precedents information for almost all recent appeal cases, and not long after the judgment or decision. In addition, for important judgment, summarizes and prepared and published and translated into the English. And the case information on this website receives a lot of hits and is likely to be widely used by the public. The prompt publication judgment has been well received by not only by the practitioners but also the scholars and the overseas researchers as well. The publication of this case law information appears to increase the predictability of the IP High Court's decisions in the field of IP dispute resolution. In addition, IP High Court's website also provides a comprehensive introduction to its procedures, including the introduction to the trial management model, I believe has enabled the court to proceed in a timely manner. Furthermore, the Intellectual Property High Court's website introduces many IP-related papers and information exchanges with the people the overseas. We also endeavor to announce recent topics by posting information on X. We also post articles that will help young students and others understand the IP High Courts and IP litigation. IP High Courts actively engages in international exchanges and welcomes visitors from overseas. Every year, the court receives many visitors from various countries, including the US, Europe, Asia, and Africa. In some years, the number of visitors has exceeded 300. By exchanging opinion with these people, the judges of the IP High Court are able to broaden their own perspectives and are given the opportunity to develop awareness of global trends in intellectual property cases that transcends national border. In an age of the discussion in the field of intellectual property expanding internationally and harmonization in this field is required, I believe it is a great opportunity for the judges of the IP High Court to be given an opportunity to look at the world. In addition, almost every year, judges of the IP High Court participate in international conferences that bring together judges and overseas, where they introduce Japan's intellectual property litigation practice and exchange opinion with judges and other international colleagues. So I believe that knowledge the gain from this exchange of opinion of the great help in hearing intellectual IP cases in Japan. And of course, JSIP is also a very important opportunity for International Exchange for the Intellectual Property High Court. This is a path that the IPA High Court has taken in the 20 years since its establishment. I have been able to introduce the achievement we made through their tireless efforts to ensure prompt and appropriate dispute resolution at the IP High Court. Of course, there is still much of the IP High Court can do, but I hope that we will continue to work hard. So having said that, it is important to emphasize that the next 20 years will be very different from the past. Rapid development of AI is poised to transform many things we have taken for granted. So from the substantive law perspective, the question of how to deal with inventions created by AI is already emerging in various jurisdictions. This issue will force us to rethink the very reason IP law exists. Of course, I don't have a clear answer as to how the court should respond to future development brought by a new technology. However, one thing is certain, now is not the time to be complacent. I have that with the participation of distinguished guests from overseas today, we can exchange diverse perspectives and opinions and prepare ourselves mentally for what may come in the future. This concludes my keynote speech on the 20 years of history of the IP High Court. Thank you very much for your kind attention.
Thank you very much, Mr. Honda, Chief Judge of the Intellectual Property High Court.